the present amendment has been brought in. So this amendment, one of the major feature of this amendment is that it allows the people practicing traditional Indian systems of medicine like Hakims, Vaidyas, and all those who are registered medical practitioners under the Ayush, and the companies making medicinal products, they can continue to do their business without taking permission from the National Biological Authority for using the biological resources. And there had been significant changes in the composition of the authority. And again, it also seeks to reduce the pressure on the medicinal plants by encouraging cultivation of medicinal plants. Farming of medicinal plants will increase the scope of Ayush system, and there is provision for fast tracking research, and the patent process, application process, has also been simplified. So these are the major areas which our experts would be discussing today. But there are certain concerns expressed by the legal fraternity and the other stakeholders with respect to the amendment bill. One is the way in which it has been pushed. It has been pushed in a very fast manner without going for the discussion. I just sought your attention to the level of discussions which started in 1995, and the process of discussion continued and finally culminated in the enactment of the Biological Diversity Act in the year 2002. You can imagine what a series of discussion, serious discussion had been taken place in those days. Again, this amendment, proposed amendment bill, has raised some concerns, because it is feared that the loopholes in the system, wherein certain concessions or certain leverage which are given to the traditional Ayush company, traditional medicinal system and its practitioners, may be exploited by corporates, multinational corporations, and corporate interest will be served. So these are the major concerns which are expressed by the critics. So let us discuss on that. As far as India is concerned, we know one thing. Most of the time, it is seen that the legal process, lawmaking process, have been pushed through by vested interest groups, including the corporates. It is a sad thing that the lawmaking process is taken over by corporate interest at some point of time. So this shall not happen with the proposed amendment. The discussion which we are holding today, it is not an isolated discussion. It is part of a number of discussions being held across the country by intellectuals, by stakeholders, by lawyers, and others, academia. So this discussion itself will go a long way. So I invite the panelists and each of you to take the issue seriously and take further discussion. With these words, I would like to leave the platform open for discussion. Thank you very much.
Thank you, sir, for your opening remarks. Today's panelists include three speakers. So the first will be Ms. Veena Jose ma'am, followed by Jyoti Nadkani ma'am, and Dr. Anil Variyat sir. So about Veena ma'am, Veena Jose ma'am is an assistant professor at Maharashtra National Law University, Nagpur. Previously, she was working as an assistant professor at Dharamshala National Law University, Jabalpur, Madhya Pradesh, where she was also heading the Center for Law, Ethics and Biomedicine. Dr. Veena has more than 12 years of experience in teaching law at various universities. Her experience and research is evident from the publications to her credit on a variety of subjects in law. She's a member of the editorial board of various law journals and is also a part of the institutional ethics committees in various medical schools. She's regularly invited speaker and resource person for the conferences and workshops, especially on issues related to human rights and medical law. She was coordinating the PG Diploma course in medical law, ethics, and science. She is also a regularly invited resource person for CMEs and the Conference for Medical Practitioners and Healthcare Professionals. She is associated with the Department of Health and Family Welfare, Government of Kerala in drafting policy documents relating to organ donation and brain stem death certification. All these initiatives and projects undertaken by the speakers are intriguing and interesting, and this makes us learn more about the topic. So I request Veena ma'am to kindly share her thoughts and experience. Ma'am, Veena ma'am, you may continue.
Connectivity. I was just checking. Can you hear me right now?
Yes, ma'am, you're audible and
I
visible.
was not listening. I mean, I couldn't listen what you told in the end, so that is why I was a little confused. There was an issue with the internet, I guess.
No, ma'am, you
So,
are perfectly
you
audible.
want me to start? All right. Okay. What did you? I mean, with
Yes.
what sentence you ended your speech? I did not hear that.
Yeah, I said that it was very interesting on our part to learn about the initiatives that you've taken, and we are very interested to learn more about them. So I would like you to explain them more, like in a brief, better way, so that we can have our interest and curiosity control.
Okay. You want me to start with the Biodiversity Act Amendment Bill?
Yes, ma'am, you can.
I'm so sorry here, internet connection, some problem, not getting what you're telling. All right. So, first of all, thank you, Professor Dilip sir and Professor Anil sir for inviting me for this particular discussion, panel discussion on Biological Diversity Amendment Bill 2021. And we know we have been discussing on this topic for some time right now, like at least 2-3 months. Almost every university, law university might have discussed consequences or the impact which this particular bill is going to create. And even in Maharashtra National Law University, Nagpur also, we had a discussion, like we discussed the same bill for around 2 days in our faculty meeting, and we were like coming up with various points to be added or deleted. So whatever suggestions we have. So to start with, we know that this Convention on Biological Diversity, which is again a part of the Rio Earth Summit, which took place in 1992, and as a result, this Convention on Biological Diversity was, it came into force, or it came into effect, and being a party to CBD, India came up with this new legislation, as Anil sir was explaining the process which took place for many years. The discussions went on for many years, and finally we got this Biological Diversity Act of 2002. And if you look at the act, we know that there are 3 objectives which this particular legislation of 2002 is trying to achieve. And we are focusing right now on the 3rd objective, that is sharing of benefits which arises out of utilization of genetic resources. So the convention speaks about 3 important objectives, and the 3rd objective is of very important, it is of very important significance for us. That is sharing of the benefits arising out of utilization of genetic resources. And for that, we have the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits which are arising out of utilization to the, which is actually the protocol is to the Convention on Biological Diversity. So we, as India being party to CBD, we have 2002 legislation, and we are party or signatory to Nagoya Protocol also. So in order to achieve the object of access and benefit sharing, we have enacted the guidelines on access and benefit sharing, and we have this regulation of 2014, which actually speaks about the access and benefit sharing. And if we look at the protocol as a whole, we know that protocol speaks about fair and equitable sharing of benefits which arise out of the utilization of bioresources. So bioresources is something, as most of us know, that it comes within the purview of, sovereign rights to utilize the bioresources. It's the power within the, which is vested with the sovereign to utilize this bioresources. So when bioresource of a country is being utilized, so what benefit it is being provided to the indigenous communities or the stakeholders? So this is the entire question which we have been discussing in the regulation also. And if you look at the protocol, we can see the emphasis is on fair and equitable sharing of benefits, which is of biological resources. This speaks about and benefit sharing. Okay, so it's that aspect of fair and equitable sharing was missing when we talk about the Indian situation. So the amendment which is proposed, the draft amendment which came out in the last part of 2021, it was intended to fill the void. Okay, there was this void, how to equally and fairly distribute the benefits which arise out of the utilization of bioresources. So there was this void. How we do not know how what is the procedure to be followed, or how it can be shared equitably and fairly among the stakeholders. So this particular amendment basically proposes to fill that void. Okay, and to make it specific that since India is a party to the Nagoya Protocol, there is a need to ensure fair and equitable benefit sharing in the Act and regulations framed thereunder. So the entire question, from my viewpoint, personal viewpoint, it is all related to fair and equitable distribution or benefit sharing, okay, which arises out of the utilization of biological resources. So earlier there was no, it was just equitable sharing of benefits, and now we are bringing this fairness also into this legislation or the ambit of legislation through the new amendment. And we need to understand that when we talk about fairness and equitably distributing the access and benefit sharing, we need to actually lay down concrete parameters. So say, for example, whatever regulation we have a 2014 regulation which provides for access and benefit sharing. So whatever regulation we have, we need to understand that there should be a concreteness in the parameters which determines what is fair and what is equitable in the given facts and circumstances. So that is the challenge basically. We don't know what is the so-called fair and equitable sharing in a particular circumstance. So we need to have concrete parameters in the regulations, or in the, since regulations are not providing for that, that is why we have come up with the bill here. So if you look at the proposed amendment as a whole, we can see there are various amendments which are proposed, especially various additions. Even if you look at the, definition clauses, we can see that there are many terms which were not seen in the earlier or the definition clause of the 2002 legislation. We are trying to incorporate that. Some definitions, there are slight modifications. Some definitions, there are like huge modification which is proposed in the proposed bill. So the first welcome approach is the definition of the term access, which is provided in section 2A of the bill of 2021. So the first one itself is very important to know what is this access. Because the 2002 legislation did not speak anything about it. It spoke about access, but it did not define the term access. So that itself is a welcome attempt from the part of the new or the proposed bill or a proposed amendment. So why I'm telling this, the definition of access is important, because as all the rights and obligations under the Act arises only upon accessing the biological resource. So it is all depending upon how you access biological resources. And if you don't know the definition and concrete meaning of the term access, it creates a lot of confusion. So firstly, they have tried to incorporate the definition of the term access, which is actually a welcome approach. Then moving ahead, we can see, I'll just go through the provision also. The term bioutilization has been taken away basically from section 2 clause D, because earlier the legislation 2002, it provided biosurvey and bioutilization. But now if you look at the new proposed bill, you can see the term bioutilization is not there along with biosurvey. So bioutilization is one of the potential uses of bioresources, and excluding bioutilization would actually leave various activities which falls under the characterization or incentivization, all these aspects. So the term bioutilization should remain in the definition. So the attempt in the proposed legislation to take away or delete the part of the definition which define the term bioutilization should be amended. Okay, it should bioutilization should be kept as it is, as we see in the previous legislation of 2002. Then moving ahead, we can see the definition 2GC, which is also a new insertion in the amendment 2GC. It defines the term land race, which was actually there. The concept was actually there in chapter 10, section 41 of the previous legislation 2002. But they have defined this term, and it says that it means primitive cultivar that was grown by ancient farmers and their successors. See, here I have a small problem with the use of the term primitive. I find it a little, problematic, because the term primitive is generally used, like it has its own history, like, a colonial or racial connotation can be seen. So that term primitive can be, changed, and some other, like, instead of the term primitive. And it regulates access to biological resources by non-citizens, foreign companies, and companies registered or incorporated in India. I think my connection is lost. Am I audible?
Yes, ma'am. Extremely sorry to interrupt, but if you could just try switching on your camera so that
Camera is on,
lagging.
actually. Camera is actually on.
Yeah. If you, it would be just for connectivity issue. It would be better. But now you're completely audible. So
okay, so it's in between. It is coming and going. I don't know what is the problem. So just tell me if the connection is lost, so that I'll stop it there. So what I was referring to is section 3, where you can see the important provision that it regulates access to biological resources by non-citizens, by foreign companies, and companies registered or incorporated in India, but having foreign participation in capital. Or can I suggest something? Can you please start with the other presentation so that I can fix this and come back, because I'm feeling that in between my connection is getting lost.
yes, surely, ma'am.
Give me 5 minutes, so I'll be joining once again.
Yes.
Right.
Yes. Okay. So, thank you, ma'am. She'll be joining us in 5 minutes. So till then, the second speaker is Ms. Jyoti Nadkat, ma'am. So Ms. Jyoti Nadkat, ma'am, was an animal welfare officer at Bombay Society for the Prevention of Cruelty to Animals, including the Sakrabai Dinshaw Hospital for Animals, and that was affiliated to the Animal Welfare Board of India and RSPCA London from 93 to 2002, and has been a nominee of CPC CPCSEA, which is the Committee for the Purpose of Control on Scientific Experimentation on Animals. She is the chairperson for Friends of City Park Committee of Nature, Kenya, Nairobi. From 2009 to 2012. Ma'am is a member of Ghana Planetarium Society from 2013 to 15, along with being the chairperson for Kenya Women's Society 2015. Ma'am has initiated tree plantation on the barren hills of Sector 35, Khargar, which is now under CSR for hill restoration in collaboration with the Forest Department and in Nature Watch Foundation. Ma'am has initiated dry waste management and recycling in society 2017 and now spreading the change through awareness and encouraging many other societies and individuals to actively participate to achieve Khargar, that is zero dumping ground city. She commenced a thermocol recycling group along with other possible materials which can be sent for recycling, like grad clothes, furniture, shoes, etc. She is actively involved in surveying wetlands with Raigad Wetland Committee and involved in saving and restoring the habitats of Khargar. Along with all these things, ma'am was also awarded the Nav Durga Award 2021 by Diksha Mahila Manch for selfless dedication, commitments for women from different fields of work towards welfare of community. Now, may I request ma'am may I request ma'am to come and share her thoughts on the topic and her experience.
Thank you very much, Palak. First of all, I would like to thank Maharashtra National Law University for inviting me on the panel today for the discussion of Biological Biodiversity Amendment Bill 2021. Thank you to Dilip sir and Anil ji, Professor Anil, for having me here on the panel for this discussion. I am not a law person as you all are, so I'm not very thorough about the law. But being working in the field of environment and conservation, there are certain facts, certain things which we always come across the dilemma, whereby we always feel that there are certain loopholes in the law where things have to be rectified or need amendment to safeguard them. When I went through this bill, um, it was an opportunity for me also to explore my horizon, because I came from a very different sect and I started working in a very different field, slowly exploring my zone, my area. And this is another adding to it. From henceforth, I'll be looking more into the laws and the bills which are passing, so which can be helpful for our work. And it will open our more horizon to see where these loopholes are and what is happening to the system, whereby we can save these the habitats, the biodiversity which are there in our country, in our society. So this basically the Biodiversity Amendment Law 2021, uh, most of them are focusing, I have gone through these, I have seen they are focusing basically on the right of patent research, the Nagoya Treaty. But somewhere down the line, these things have to be taken care of. They are absolutely important, especially when it comes to uh, 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 safeguarding our resources, compared to when a foreign company comes in or a foreign individual comes in. And we have seen how in past our things have been patented by them without our knowledge, and then we realize that, oh, these were our products, these were our research work, and they were patented. So this is a very important step. It has been taken over. We have to make sure that our things, our knowledge, uh, are restored back in our country, and it's not being just taken away by somebody else. But along with that, one thing I have noticed that uh, the Biodiversity Protection Act, which was there, the law which is there to protect the biodiversity, conservation is not much spoken about. We are talking about the medicinal plant, we are talking about the herbs, We are talking about the rich flora and fauna which is there in the country, to preserve that. But in the entire amendment, there is access for the Ayush. There is amendment for the Ayush companies, there for the Hakims, for the Ved, for the researchers, for the patents, but there is very small scope, or hardly anything is mentioned about the conservation and the protection of the biodiversity which we are working on. Your There is a thing that there is a clause whereby, they have stated that you can practice, you can cultivate the medicines and the herbs, so that they have been protected. We can have the herbs can be increased by farming. The farmers are given right under FRP Act, the Seeds Act. But what about the other places whereby these flora, the herbs and the medicinal, the plants which are available but are not in protected zone, and they have been destroyed? Oh, there is nothing much given for their protection. So we have to see that, their protection also is being covered in the amendment, because earlier there was this penalty which has now been reduced. The penalty has also now been reduced, so that can be another loophole whereby it will give an open space to the people to explore them or to exploit them, because the penalty have reduced. So we have to work to it. A stringent law has to be kept on, so that, these natural, the habitat which is there, the place, the biodiversity sensitive zones which are there, are not destroyed. Because now we see in our country everywhere, the zones are completely being destroyed in each and every corner, uh, either for development purpose or for some other purpose. But then these protection, if they are reduced, it will harm them more. So I think when we are looking into this amendment act, we have to also make sure that the biodiversity is also protected, and the penalties which are there, the act which is there to protect them, is also very stringent. It doesn't loosen up, or there is no reduction, or there is no um, uh, compromise done on the safety, on the protection of these biodiversity. Especially, I also went through those three boards which were there to safeguard these panels, the three panels which were made: the National Biodiversity Board, the State Board, and the local. Uh, in both the boards, there were certain specifications which I have seen, which I have gone through, that how a person will be appointed, what will be the qualification of the person who will be appointed on the board, whether it is national or state level. But when it comes to local, there is no specification, much clarity given on the local level appointment of these people. And I have seen in our state, I mean in our jurisdiction, the state board has been appointed, the local level biodiversity committee has been appointed, management committee has been appointed, but it is not doing much. And the people who are there on the committee, most of them doesn't know much about these biodiversity which are around in our region, how to protect them, what steps and what measures have to be taken to protect them, what restoration work has to be done, what kind of classifications or data has to be collected and maintained. There is nothing much done about it. So I think these points also have to be mentioned, and they have to be also taken into consideration when there is an amendment in the biodiversity bill, other than the patent and research and Ayush, what we are looking into for a broader aspect, for the larger community gain. But these are also very basic, because these are finally the foundation, the main point, and the main uh, place where the biodiversity stands. And if this foundation is disturbed, and this is destroyed, then we don't have much. We can only survive on the cultivated ones, but the wild flora and fauna will not be there much to be seen. Yes, well, like that's what I have to say as of now. Then I can add more points to it.
Thank you so much, ma'am, for your words. Veena, ma'am,
Yes, right now, am I audible?
Yeah, you are.
Okay, I'll try. So we were discussing a few provisions which I found it to be, either problematic or a welcoming provision. This is what I was discussing. So we were on section 3, and ma'am, in between, thank you so much for such a wonderful, outlook about the statute, especially from the perspective of people who actually work for that. So from our side, what we can do is just to look at the wordings of the law and say, okay, this should not be like this. But from the practical viewpoint, when we listen to that, it's of great significance, basically. So we were talking about section 3, where which is again very important provision in the Act, and it basically regulates access to biological resources by non-citizens, by foreign companies, and companies registered or incorporated in India, but having foreign participation in share capital or management. Okay, so if you look at the further provision, like 3 clause 2, subclause C, and again clause 2 of the original Act, it had prohibited body corporate, incorporated, or registered in India under any law for the time being in force, which has any non-Indian participation in its capital share or management without the prior approval of NBA. So this used to be the provision in the original legislation. Okay, and now if you look at the amendment bill, we can see under 3 clause 2, subclause C, again clause 2, it has introduced a new term, foreign controlled company, into the section. Okay, so again, this particular term, foreign controlled company, is creating a lot of confusion, because even if you look at section 2 clause 42 of the Companies Act, where a foreign company is defined, see, there is a lot of mismatch. Basically, this is what I intend to say, especially with this particular term, that is foreign controlled company, which we can see in section 3 clause 2 subclause C. Then obviously this is going to bring a lot of complications, confusions, etc., because the term itself is not clear. And moving ahead to section 4, here also there is a confusion. A new term has been introduced after the word person. Okay, and the new term is entity. But nowhere in the bill we can see the term has been defined. Entity has not been defined. Again, it is going to, leave scope for unnecessary confusion, and ultimately it will lead to more litigation. Again, coming to section 6, section 6 deals with application for any IPR in or outside India for an invention based on any research or information on a biological resource addressed from India to be made after obtaining NBA's approval. And the word obtained in biological resource, which is obtained from India, has been replaced with accessed. And that is actually a welcome move. When this term obtained has been replaced with access, the entire scope of section 6 appears to be enlarged altogether. So earlier, this Act of 2002 was restricted only to biological resources, but now we know that it also covers the repositories which are outside India and associated traditional knowledge, which is again a good step forward in order to ensure the foreign ensure the sovereign rights over the biological resources. But again, there is a confusion with the term. Not traditional knowledge. There is one term which requires, again, one second, I'm just taking the statute where I can tell you. Yeah, the term is codified traditional knowledge. So again, there is a problem whether codified knowledge can be considered as a traditional knowledge or not. So if you look at the definition of the term traditional knowledge in its general parlance, we know that traditional knowledge is essentially uncodified knowledge. So here the term which is used is codified traditional knowledge, which is again confusing. So that is yet another point which I wanted to make. Then moving ahead to the next important section, that is section 7. Section 7, again, Section 7 provides or it regulates access to biological resources by Indian citizens, body corporates, and other associations registered in India. And the only requirement here is prior intimation to SBB before accessing biological resources. So the term prior intimation is being used in the statute, in the bill. But what is required is prior permission. It's not just the intimation and permission, prior intimation and prior permission. It makes a lot of difference. So what we suggest is it should be replaced by the term prior permission. That means at the time of granting permission itself, SBB will be in a better position to impose regulations relating to the access and benefit sharing arrangements. So at the initial stage itself, while applying for permission, then the power is with the SBB to give regulations or fix or put in conditions. Basically, intimation means I'm just informing you, that's it. But what we require is prior permission from SBB. Then again, moving on to section 21, we can see the amendment bill has replaced equitable benefit sharing with the term fair and equitable benefit sharing. So this is exactly what the entire thread which runs through the amendment is this. That means instead of the term equitable benefit sharing, they have added the term fair and equitable benefit sharing. But even then, if you look at the bill proposed amendment in toto, we can see how to ascertain this fairness and equitableness. Like all throughout the statute, it's very difficult for us to find out how this can be implemented. There are no pointers basically. We don't know how to ensure this fairness. So that is yet another drawback which I could identify in the entire bill. Again, moving on to section 55. This amendment bill seeks to decriminalize the act by removing the penal provisions which are contained in section 55. So earlier, non-compliance, it invited penal provisions, but now that entire thing has been taken away. Okay, so yes, we know it's all about fear of punishment, isn't it? So the fear of punishment is one small factor which definitely reduces the crime in that perspective. So in my personal opinion, I believe the penal provisions of imprisonment should be retained in the statute. And the section 55A, which is proposed, it may be repealed as of the penalty and the fine, both shall be imposed by the court. And section 55B, yet again, is a welcome addition. It empowers adjudication mechanism with the powers of inspection, survey, search, etc. So it is strengthening on the one side and it is weakening on the other side. So what I would identify, or my personal reflection is that all those provisions which were there in existence, like 55 to 58, it should be retained as it is. The earlier legislation, the 2002 version of the statute, it contained better provisions. Section 55 to 58, it was much better when compared to the new changes which are brought about in the bill. So basically, these are the pointers which I would like to highlight in this discussion. So I think that's it. Yes, over to you, Palak.
Thank you, ma'am, for your kind words and such important things that we really need to know in order to understand the bill. So I would just request if anybody has any questions, they can just write them in the chat box or unmute them and ask the questions.
Look, I guess we don't have any questions from anyone in the chat box as well.
Yeah, okay. I had a question, if I may.
Yeah, sure.
So, Jyoti ma'am, you talked about the people who are the stakeholders not being aware, like when they are making the bill or drafting it, they themselves are not aware of the net integrities that they should have for a bill to be made as a complete package or it to be a completely well-drafted bill. So, what do you think can be done for people like you or someone who are more interested or more knowledgeable for the purpose of that thing to be laid out very well? What other things that should be done for that process?
See, when this bill or this was drafted, the point was considered, maybe the focus was more on the Ayush sector, the foreign investment, then people who are farmers who are going to cultivate these medicines, what are the profit they are going to get, and under the Treaty of Nagoya for the local community, how are they going to benefit? And then the patent and the research, how fast, maybe these are the if you see the bill, why it was formulated and what is the reason why it is passed. So if you just focus on those things, you will understand. As a layperson, for me, I will understand that this was only focused for particular company, for a particular division, for a particular sect. So these are the people who must have pressurized the particular ministries or the department. These are the things we are facing problems while patenting, while doing the research, collecting the research papers, or while getting the foreign investment, or cultivating crops, or getting herbs for to make the more medicines for their products. So these are the problems they were facing, and this is why this was pressurized to the department, and maybe this was the only focus they had. And that is why the entire bill mostly revolves around that whole scenario, other than safeguarding the biodiversity which is there, looking into the pattern, the matter that who are going to be on the board, who are going to decide about the local biodiversity management committee or state board committee. What are the different places, what are the different habitats or biodiversity sensitive zones which are there in the region, which needs to be secured. Finally, there are some herbs which are cultivated, but the main seeds, the main plant, the mother plant and the seed is coming from the wild. So from the wild, if the species get extinct, how are you going to cultivate it on a commercial base? You have XYZ right now at the commercial basis. Fine, you have your seed bank with these particular Brahmi or Ashwagandha or whatever XYZ herbs are there. But there are much more herbs which are found in the wild, and they are on the threat. They are on the threat of extinction because of the continuous demolition and destruction which is happening in the biodiversity in the actual world, where due to development and constructions, especially our hills, which are the source of all these herbs, they are not protected. Every day, some of the other sensitive zone has been quarried, they have been mined, they have been taken the mined for the soil, for stones. So all these herbs which sometimes come in monsoon, you don't get to see them in dry season or winters, but some of them come during monsoon. The rate of these herbs are much more higher in monsoon. So all these things are not there, they're slowly getting extinct. There is nothing there done for this protection. So people need to know that when we formulate an amendment act, other than these particular things which are required for our commercial growth, for our development of the society, to increase our GDP, basically, what are the things you have done to restore the main biodiversity of the country, which is which is degrading day by day for one or the other reason? So those things have to be taken into consideration. We spoke about heritage site in this bill. There is one section where we have mentioned biodiversity heritage. How do we register those heritage sites? There is nothing more clarity given on that. Where does one go? What are the parameters to register those biodiversity heritage site? How does one conserve it? How does one get it gazetted so that the destruction to these places where we know these are the sources of flora, rich flora, how do we save them? So my basic concern is, when we formulate these acts, there has to be a protection act and restoration act for these things also. Even the panels which are coming on board, It doesn't matter whether you have degree for those things. I have seen people, ma'am is very much knowledgeable. I'm really thrilled, to come on this panel and get more enlightened, because this is for me a first time that I have come on a law panel and discuss. In fact, I was not very confident. I spoke to Nirnaya also. Oh, what am I going to say? Because I'm not a law person. So this is not my field. But when it comes to protection, I know law acts very firm in this, and we need to modify. So people who are there in this department, they need to be dedicated, and they need to be thoroughly informed of what they are doing and where they are doing. Like for instance, we have a good example of my local body, which is holding a biodiversity management committee. But till date, there are so many destruction happening in and around our locality. We have approached them, nothing has been done to save them. So what is the point of having such biodiversity management committee who has not done anything to safeguard these biodiversity spots and hotspots and sensitive zone? So we need to also focus on these points, and there has to be some definitions and parameters. Not only, you can't only look after the degrees, but also the interest of the person who's going to safeguard these heritage for the future generation. Ma'am, what do you have to say about this?
If I may add 2 points to this, ma'am. First is, if you look at the new proposed amendment bill, we can see the entire thing is, as you said, focusing on the corporate sectors, their benefits, all those things. Plus, the Ayush is also being, the Ayush practitioners is also being taken care of, well taken care of. That is one point which I would like to highlight. And the second one is, see, especially this kind of legislation where a lot of local indigenous populations and communities are involved, there should be a unanimity, or what I should say, the stakeholders, those people who are actually working for this, they should also be brought together. They should be informed. Okay, this is what is happening, and this is how it should be. So that aspect also has to be taken care of. Then only we can see the success of this attempt. Otherwise, it is like somebody is. We all are sitting in the national law universities and speaking hours on biological diversity, and I don't know what exactly is happening at the ground level. Only when you are speaking from that perspective, we are coming to know that, okay, this is the ground reality. So there should be a group where all the stakeholders, let it be legal academia, let it be the stakeholders, including the indigenous communities, everybody should be given equal participation in the discussions, and then only it should go to the final drafting stage.
Absolutely, that has to be done before anything decided regarding the environment and biodiversity. Agreed.
Right, ma'am. So if there are any other questions or anything more to be discussed, we can.
Am I audible? Hello, Palak.
Yes, you
Am I
are.
audible? Yes.
Yes,
Thank
you
you.
are.
I would like to add something more in this discussion. I am Amit More, in charge principal of PDPL Law College, Fulton. So, as guidance given by Veena ma'am and Jyoti ma'am, I am very happy to have such a subject and such a discussion forum here. Firstly, I would like to disclose one thing. I am doing my PhD thesis on this subject. So, I specially joined this one meeting, very interested. Now I'd like to, whatever question rose by Veena ma'am and Jyoti ma'am, I would like to further add few things. Two things that in all over the world, there are 7 hotspots we found about biological diversity. And instead, we should be very proud to feel that out of those, 2 are situated in India. And one of them is the Western Ghat of Maharashtra, particularly. And especially when we talk about this topic, we have to consider 2 things. There are biological diversities we found in animals and plants. Particularly this bill, as what we discussed today, here there is a lack of a thing that we think when parliament or government has failed to take or incorporate the provisions relating to, as just told by Jyoti ma'am, that ground reality is not considered. because we seen whatever in my thesis also I incorporated these things, that the things like forest fire, or people when goes to any adventure as such, uh, forest catches many time fires, and lot of there are threatened species in both plants and animals which are reflected here. And this bill is just focused on commercialization only. And even we found that penal provisions are removed, and biological diversity is such a thing which attracts environmental laws, including plant laws, forest laws, environment protection laws. But we feel, I feel that there is a very much lacunas in protecting particularly biodiversity, because biodiversity is subject of environmental law also and intellectual property law also. So I think this bill is something inadequate, in the sense that it doesn't cover anything that just discussed by Jyoti ma'am, or punishments or whatever on environmental point of view. It is just covering on um, the basis of commercialization or taking some medicines or plants. Even though on another side, I would like to tell here, and then I will stop, that there are Adivasis who are living in forest area, but they are not particularly focusing to disturb the forest fauna and flora and fauna. So we the people who are not observing the ground realities, and particularly this legislation should contain, I think it should contain all the things, but I think it is inadequate. So thank you very much for giving me an opportunity to speak here. Thank you.
Naya ma'am, I think we're done with the questions. So if you could just take over.
So, good afternoon to one and all present here. I, Nirnaya Gadekar, would like to extend vote of thanks on behalf of Maharashtra National Law University, Mumbai, and everyone present here. I would like to propose the vote of thanks to Dr. Veena ma'am and Jyoti ma'am for enlightening our minds with the thoughts with respect to the amendment bill. Thank you so much for categorically putting forth all the concepts that were needed to be known by everyone. As Jyoti ma'am has put forth the ground realities, Veena ma'am has made sure that we were well aware about all the legal provisions with respect to the same. I would like to thank both of you for making us understand this bill in every possible way. I would also like to take this opportunity to thank our Vice Chancellor, Professor Dr. Dilip Uke, and Honorable Registrar Sir, Professor Dr. Anil Variat, for giving us the platform and the constant support for organizing such events. I would also like to thank Palak for moderating the session today. I would also like to thank all the teaching and non-teaching staff participating here. I would like to give the special thank to the technical support from Manohar sir. And last but not the least, I would like to thank to all the participants for being the part of today's webinar. Having said this, I would like to conclude the webinar for today. Thank you everyone for joining us today.
Yes, thank you. Thank you very much.
Thank you, sir.
Thank you,
ma'am.
thank you, madam. Thank you.
Thank you.
Thank you.
Thank you so very much, sir.
Yeah, thank you very much. Thank you for joining us.